Awesome. Good morning. Good morning, EO Nashville. Thanks for joining us today. I think it's our 23rd installment of the EO Exchange series, and thanks everybody for being here, either live or coming back in to watch it later. Today, we have Martha Boyd with Baker Donaldson, and she's prepared a timely and informative exchange for us this morning. Chapter is, every SAP, especially Baker. I know Martha's done a lot of these, and very thankful for all the SAPs and to Baker this morning specifically. Martha is a shareholder in the Labor and Employment Practice Group at Baker Donaldson, where she guides managers through discipline and discharge. She trains managers and first-line supervisors in a variety of topics through interactive sessions, including discrimination, harassment, and workplace violence. She also advises businesses on the use of non-competes and non-solicitation agreements for employees and how or when those agreements should be leveraged in light of a particular labor pool. She's a graduate of Vanderbilt University School of Law, is a U.S. Army veteran, and she served in Operation Iraqi Freedom, which always impresses me for sure. Just a couple things. Martha's going to do about 30 minutes, just a reminder on the schedule. About 30 minutes, and then we're going to have 15 minutes of Q&A, so please drop your questions in the chat when they come to you, and we'll get around to them at the bottom of the hour. I feel like a radio DJ saying that. And what else am I missing? There's going to be a survey, so be sure you knock that out and make sure I'm checking all my boxes here. I think we're ready to go, and I'm sure if I miss something, I'll remember later. Martha, thanks, and take it away.
Thanks, Richard. Well, thanks for having me today. And, depending on your perspective, non-compete agreements are either one of the best ways for an employer to protect your valuable IP and confidential information, or a mechanism to stifle employee competition and keep wages unnaturally low. I suspect the truth, like most things, is somewhere in the middle, but either way, non-competes are widely used in business today. Statistics show that somewhere between 18 and 28% of the current U.S. labor force is bound by a non-compete. It won't surprise you to know non-competes are more common among executives. Probably 70 to 80% of executives have non-competes. Technical workers are also, tend to be bound by non-competes, some 30 to 45%. Physicians are bound by non-competes, as we were talking about earlier. Lawyers are not able to be bound by non-competes. Physicians are. But what's surprising, I think, is there are a large percentage of low-paid, less technical workers who sign non-competes. 14% of those earning less than $40,000 are bound by non-competes, and 53% of the workers who are bound by non-competes are hourly workers. These numbers may be somewhat surprising, but my guess is that they are so high, particularly among the lower wage workers, because a lot of employers just have all their employees sign non-competes without giving much thought to whether a non-compete is appropriate, considering an employee's job duties, their exposure to your confidential information, or their interactions with your customers. So my hope is that you'll come out of this today with a better understanding of how to use non-competes, how to make sure they're enforceable for the particular employees you're asking to sign them. I want to talk about a few myths about non-competes that I'm hoping we can clear up today. I've had employers call me and say, well, non-competes are illegal, aren't they? And the fact is that they aren't. In most states, including Tennessee, they are legal. There are 3 states where they're illegal: California, North Dakota, and Oklahoma. And in California and North Dakota, they are still allowed in limited context in connection with the sale of a business. Non-competes are unenforceable. Again, not true sort of across the board. Now, in many states, courts will say things like non-competes are disfavored because they're restraints on trade, and then they go ahead and enforce them as long as the non-compete meets all the requirements of that state. So assuming they are written appropriately in accordance with state law, they're enforceable. Another myth I keep hearing is that non-competes are not enforceable if the employee you're seeking to enforce was fired. And that's not the case either. And if it were, that would certainly incentivize bad behavior. An employee who wants to get out of a non-compete could simply, deck their supervisor and get out of it. So there are a few states that have said that the non-compete can't be enforced against an employee who is terminated without cause, but they can if the employee is terminated for cause. Very few states address that issue. Another is that the non-compete is non-enforceable if the employer didn't sign it. So what happens often with non-competes is the employee signs it in onboarding. The HR or head of the company takes the non-compete, puts it in the employee file, and then forgets all about it, forgets to sign it, in other words, and pulls it out 3 years later when the employee has gone out and gotten a new job that is competitive. And then they're like, oops, I see that I didn't sign it. So, well, if you're the party seeking to enforce the agreement, typically it's still enforceable even if you forgot to sign it. That said, there are a few cases from around the country where a court has said, well, you didn't sign it, so it's not enforceable. So just FYI, really, when you have an employee, a non-compete agreement, make sure you sign it before you stuff it into the employee's personnel file. And then the final myth is that non-competes have been banned by federal law, and that's not true either yet, at least. There have been rumblings, as we'll talk about federal law banning non-competes, but right now they're still legal. So let's talk real quick about what a non-competition agreement is. So it is basically just a contract between an employer and employee that restricts what the employee can do for a competitor, both during employment and after the employment relationship ends. And they're typically used to protect trade secrets or sometimes confidential information that doesn't quite rise to the statutory definition of trade secrets. And then also customer relationships. And the idea is this: so you're an awesome salesperson, you sell this really great product or service, and the salesperson is, of course, the one who develops the relationship and becomes the face of the product or service. They become the face of the company. So the customer confuses the great product or service from the company with the salesperson. And so when the salesperson leaves, that customer says, oh, I want to go with you to whatever product or service you're now selling for a competitor. So the only way to prevent that happening is to lock down that salesperson with a non-compete, and that's the appropriate sort of use of it. Non-competes can also be used in an independent contractor relationship, and I get that question a lot. You need to make sure that your independent contractor is appropriately designated as an independent contractor and isn't an employee that you're calling an independent contractor, because that's probably not an issue you want to litigate if you're trying to enforce a non-compete, but you can use them with independent contractors. They're typically only for a limited amount of time in a limited geographic area, and we'll talk about that in a minute. They're often used in conjunction with the sale of a business, and while I'll talk to you about the time limitation that you have on regular non-competes, when you're selling a business, typically you can do a non-compete of, say, 5 years. And the idea, of course, is that you don't want to sell your business and then have the person, you don't want to buy a business and then have the person who sold it to you go set up shop across the street and take all their customers and, compete against you. So non-competes are governed exclusively by state law. There's no federal law governing non-competes. As you know, we have 50 states and the District of Columbia. Non-compete laws used to be substantially similar across the country. So if you had a non-compete from Georgia or a non-compete from Louisiana or Illinois, they all pretty much followed the same pattern. They'd all pretty much be enforceable everywhere. That has changed. As I mentioned, there's a few states who have prohibited non-compete agreements from time immemorial. Recently, Washington, D.C. passed a ban on non-competes, so almost all non-competes will be illegal. And for D.C. employers, beginning, it was delayed. It was supposed to go into effect this year. Now it probably will go into effect somewhere around April of 2022. But beyond that, in the 47 states where non-competes are legal, the laws are now all over the place. So a few of the states, 26 states, rely on the common law, which is the case law, and Tennessee is like that. So in Tennessee, when we're wanting to know how a particular non-compete provision might be interpreted, we have to look at court cases to see how particular judges have looked at these laws in the past, and the exceptions is for physicians, they are governed by a statute. But in the other states, there's state statutes, and sometimes they have really picky requirements. And if you don't draft the agreement to meet exactly those requirements, you can render yourself with a non-compete that is completely unenforceable and therefore kind of useless to protect your stuff. So, you know, this massive variation means you've got to be really up to speed on what the various state laws say. And you may be wondering, hey, why is this important to you? You're here in Tennessee, so who cares about the variations of the laws in all these other states? And the fact is, you have to care because you may have employees in other states. And as we'll talk about in a minute, you can't count on another state being willing to enforce a non-compete imposed by a Tennessee company against that state's resident if the non-compete wouldn't be enforceable in that state. And the other reason you care is because you probably have encountered instances, well, where you're interviewing some great candidate, you love her, she loves you, she'd be great for your company, she accepts your offer, and then she happens to mention she has a non-compete and it's from another state. And so you may need to have to look at that non-compete and determine, hey, can I still hire this person? Do I want to hire this person? Or is this going to put me at risk for a lawsuit if I do? So there's other restrictive covenants that are often included in non-compete agreements that also help you protect your stuff. So non-disclosure prevents an employee from disclosing your confidential information. Great to have a non-disclosure agreement. It doesn't offer you quite as much protection as a non-compete because if an former employee goes to work for your competitor, you may have difficulty knowing if they're using your confidential information or not. And that's why having both a non-disclosure and a non-compete is helpful for protecting your IP and your confidential information. Non-solicitation agreements, you know, again, they protect your customers, your clients. They prevent your employees from leaving you and then calling on your customers or clients to try to get business for a competitive company. These are difficult to enforce because it's really hard to prove when somebody has called on one of your customers, unless you have a customer who calls you, which happens from time to time, and says, hey, by the way, I know Frida left you and has gone to this other company. She called me last week seeking my business. But unless that happens, it's kind of hard to enforce. We have non-solicitation of employee agreements, sometimes called non-recruitment agreements. And these mean you're not going to leave and call on your former coworkers to come work for them. You can sometimes use non-interference provisions, and this just says former employee won't do anything to interfere with a business relationship that you have. There are garden leave provisions where you would pay a person while they're on a while they're in a non-competition period, and courts really don't really scrutinize those very carefully. So if you say, look, I don't want you to compete with me a year after your employment ends, but I'm going to pay you your regular salary that whole time. I mean, it's kind of hard for a court to really get too exercised about that. I mean, that seems pretty reasonable. Let's see. So non-competes are generally enforceable if they are reasonable. And obviously the term reasonable is a rather subjective term, but reasonable has to be within reasonable in duration. So typically 1 to 2 years is considered reasonable. They have to be reasonable in geographic scope. And it's typically they're limited to the territory where the employee worked for you. So there's a temptation on the part of a lot of employers to say, well, I'm going to tie this person down for 3 or 4 years, or I'm going to tie them down to the entire world because, you know, we do business on the internet and they could legitimately, you know, compete with me anywhere in the world. And, you know, your best bet with both duration and geographic restrictions is to limit it to what really protects your company. And you should know that while in Tennessee, reasonable is just considered typically 2 years is fine. But there's a bunch of states that have now enacted laws that limit the duration of non-compete. So Oregon has limited it to 18 months, and then it's going to go down to 12 months in 2022. Massachusetts has limited them to 1 year. So there's sort of a trend across the states to limit the duration of a non-compete. And then, you know, in terms of the geographic reach, you want it to be the smallest sort of, you know, geographic area that a court is going to look at and see that's reasonable, because that's really where that person is doing business with you. You want to be reasonable in the scope of the protected or restricted activity. So if you have an employee who works for a manufacturer of radar equipment for commercial aircraft, and you restrict that employee from working anywhere in the aviation industry, that's going to be considered an unreasonable scope. So you would want to only restrict that person from working for another radar equipment, you know, company. And then you've got to have a business interest to protect. So, you know, you've got to have something that where if somebody left and went to a competitor, they could really hurt you. So you confidential customer data or marketing strategies, things like that. Just not wanting an employee to work for a non-compete or working for a competitor because you don't like that isn't going to fly. You've got to have something that's, you know, a secret sauce to protect, if you will. And then finally, the non-compete has to include consideration. And consideration is just a legal way of saying that if the employee gives something in the form of a pledge not to compete, the employer has to give something as well. So in most states, the consideration for signing a non-compete agreement is just continued employment. And that's the case here in Tennessee, even if that continued employment is at will. So if you are 2 years into an employment relationship here in Tennessee, you haven't had your employee sign a non-compete yet, but you want them to do so now, it's fine for you to just say, here we are, Tennessee, sign this non-compete. And the promise of, you know, just based on the promise of continued at-will employment is fine. Now, if you were to fire that employee tomorrow after they sign that non-compete today, a court might be hesitant to enforce that, but generally that's okay. But there are some states where continued at-will employment is not considered sufficient because it really doesn't require the employee to do anything. So states like Kentucky, North Carolina, Montana are all states where continued employment alone is not sufficient consideration. So in those states, you'll want to be sure and give the employee something else. So a pay raise, a one-time bonus, a promotion, a promise that they can only be terminated with cause or something like that. And so if you want to make an agreement that is, you know, just generally going to meet any state's statute, it's not a bad idea just to include some consideration. It doesn't have to be like, you know, $10,000. It could be, you know, $250 or something like that, sort of a bonus of some sort. In the past, until the past 10 years or so, non-compete laws among the various states were relatively similar. So if the non-compete was reasonable in terms of time, scope of the activities prohibited, courts would generally enforce them. But there was a wave of what was seen as sort of abusive or anti-competitive behavior by employers using non-competes that changed all that. And you can thank Jimmy Johns for the wave of non-compete legislation. So Jimmy Johns, the sandwich shop franchisor, had its employees sign non-compete agreements. So to work at Jimmy Johns, the employees had to agree that for 2 years post-employment, they wouldn't work at another business that earns 10% of its revenue from selling submarine sandwiches or that was located 3 miles from a Jimmy John's store. So the guy asking you if you want lettuce was required to sign a non-compete. The janitor was required to sign a non-compete. The attorneys general of New York and Illinois went after Jimmy John's, and this led to a public outcry against non-compete for low-wage workers. Jimmy John's was deemed to be using the non-compete solely to prevent its employees from leaving in a tight labor market. There was no secret sauce, right? It's just mayonnaise, right? So there was no specialized skill. There was no access to company confidential information that these sandwich makers had. So Jimmy John's ended up having to pledge to rescind all the non-compete agreements, to tell all their employees that they weren't enforceable, and pay a big fine to the AGs of New York and Illinois. And in the midst of this controversy, there was sort of this federal effort to start to ban non-competes that arose in 2015, and states followed. And, Illinois immediately started limiting non-competes. A bunch of states have limited non-competes for lower wage workers. And then in July of this year, President Biden signed an executive order directing some federal agencies to implement action to increase competition and limit the power of corporations. The EO that he issued doesn't actually require any particular action. It encouraged the Federal Trade Commission to take action to curtail the unfair use of non-competes. And although the executive order doesn't require immediate action, we're sort of all waiting to see what the FTC will do. FTC commissioners have expressed publicly a desire to regulate non-competes, but we all expect to see something happening here in the next little bit, but it may just be restriction on the use of non-competes for lower wage workers or something like that. So another significant trend in non-compete law in some states is to require employers to give notice to employees that a non-compete will be required. So often an employee will walk in the first day of work and they'll get a whole host of documents to sign, their employee acknowledgement of the employee handbook and their W-4 form and a non-compete. And so they didn't even know this was coming. They don't really have an adequate opportunity to review it. They don't really know what they're signing. And so a lot of states have said, that doesn't seem really fair. They ought to be able to know before they accept the job in some cases that they're going to be required to sign a non-compete. So some states have started requiring advance notice. One state, I think it's Virginia, requires employers to post the non-compete statute in that state on the bulletin board where you post other things. And then one state requires, I believe it's Oregon, requires that when employees leave, you have to tell them, remind them that they have a non-compete and send it to them. Now, that seems a little onerous because it's one of those things that an employer could sort of forget to do. But as a practical matter, all of you should be providing a copy of your non-compete to a departing employee and letting them know that you plan to enforce it. And you can do this nicely. I write letters for employers all the time that say, hey, Frank, we know you've left recently. We just want to remind you that you have a non-compete. Here's a copy of it, and we plan to enforce it. We don't anticipate any issues, but we do plan to enforce it. But sometimes, the person goes and works for a competitor, and then you have to send them a nastier letter that says, hey, we know you're working for a competitor, and if you don't quit, we're going to come after you. Another restriction that has been imposed is wage restrictions. So many states have said you can't impose non-competes on employees who work less than a certain threshold or who are hourly employees or things like that.
Hey, Martha, I'm going to give you a 5-minute warning.
Okay, thank you. So this is probably the most important part of this whole presentation, which is the choice of law provision. And I'm going to ask you, if you guys use non-competes, go back to your office today and look at your non-competes. They should have a choice of law provision, and it may be labeled something like choice of law or governing law or choice of law and forum. It may be lumped into a paragraph entitled miscellaneous. But the choice of law provision is really key here. I've seen employers that use this as their choice of law. This agreement shall be governed by and interpreted under the laws of the state in which the employer is located, or even worse, where the employee is located. If you're doing business in 5 different states, where is your business located? The term located, it has no legal meaning and is just going to cause trouble for you. The best choice of law state you can have is Tennessee, because Tennessee has really good non-compete law. It's very employer favorable. Unfortunately, there are states, though, that won't enforce a Tennessee or other states' choice of law provision. So states like California, they've gotten wise to the fact that if you have an employee in California, you want to bind them to a non-compete, you stick a Tennessee choice of law provision, and that means the court would have to say, well, Tennessee law applies to that. Tennessee law allows for non-compete, so we're going to enforce it. And a lot of states have said, yeah, we're not going to let that happen. We're going to protect our employees. So California, Louisiana, several states have said, we're not going to enforce another choice of law provision if it violates our non-compete statute or our non-compete law. But in general, your safest bet is to include a Tennessee choice of law provision in your non-compete agreement. That is not going to guarantee that it's going to be enforceable everywhere, but it at least gives you, a little bit of an edge if you have an opportunity to enforce it. To enforce a non-compete, some of you may have been through this process already. You're going to typically send a demand letter to the employee. And like I said, you're not going to start by filing a lawsuit. You're going to send a demand letter and you're going to say, hey, we have a non-compete. You signed it. Here it is. We expect your compliance with it. And we know you're competing with us, and stop, or we're going to sue you. And then you take the former employee to court. You're typically going to seek an injunction to try to stop them, which means they would have to actually quit their job. And a court will sometimes say they have to quit their job because they're in violation. You're also going to try to seek damages if you have suffered damages. And that's kind of a hard thing to prove sometimes. But you should, you would seek damages if they've taken a customer or something like that. You can also sue their new employer if the new employer knew about the breach. And that's why when you send that demand letter to the employee, you typically also want to send a letter to the new employer and say, hey, I don't know if you're aware, but this employee that you just hired has a non-compete that we believe is enforceable, and they're violating it by working for you. So if you don't fire them, we're going to sue you for inducing breach of contract. And there are laws that prevent a new employer from allowing an employee to continue working for them where that doing so is in violation of that employee's agreement. Unfortunately, non-compete litigation is costly. So attorney's fees are going to eat up, typically any money you save by breaking up the relationship. But that's why you definitely want to have an attorney's fees provision in your non-compete agreement that says if the employee violates it, the employee is going to be liable for attorney's fees. And then finally, think carefully about whether it's worth your while to enforce. If the employee really can't do you much damage, you may not want to enforce it. And if the employee sucked, and I often tell employers this, if the employee sucked, let him go work for a competitor. That's awesome. Then they'll go suck over there, and they'll eat up that employer's time and energy and everything. So just a few best practices, and then I'll wrap it up here in just about 2 minutes. So use a variety of these clauses to try to bind your employees. If non-solicitation clauses, non-interference clauses, all these provisions are typically enforceable even if a non-compete is not. And so you want to use a combination of clauses and really ask about with your particular employees. You don't need to bind every employee with a non-compete. Some of them just aren't going to have any information or relationships that can do you harm. So really think about who can harm you and who can't, and only have those employees who could harm you by going to a competitor sign a non-compete. Draft the non-compete so that it is no broader than what you absolutely need to protect your business, because you want a court to look at it and say, this is fair. This seems reasonable to bind this employee. If you overreach, it's going to come back and bite you. Protect your confidential information while your employees are working for you. So even if you have an NDA that protects your confidential information, you need to take steps to protect that information. So make sure the only certain employees who need that information have access to it, have, password protected certain areas where certain employees can't go, mark things as confidential, monitor misuse. So monitor when your employees are sending large emails to themselves at a Gmail or Hotmail address, see what they're doing. So you need to be able to show a court, hey, we actually took steps to protect our confidential information. Have a Tennessee choice of law provision. As I mentioned, understand it may not fly everywhere, but it's probably the best thing you can do to protect yourself. Include an assignability clause. This means that if you sell your business, the new business would get the benefit of that non-compete because you assign or transfer the non-compete protection to that new business. Tell the candidate about the requirement in advance. I think this is really important just to be sort of fair and make sure that your candidate is comfortable with the non-compete. And if they're not, if they're like, oh, I don't want to sign a non-compete, maybe that candidate was going to leave you and go compete with you. So it'd be best to know that up front. And then just conduct a legal review frequently. The laws are changing constantly. There are probably 100 statutes under scrutiny right now across the country in various states. So it's constantly changing. Just don't think that this is a static situation. And then don't just rely on your confidentiality provisions in your employee handbook. Handbooks are useless after the employee has left you. And so a non-compete or NDA or non-solicit, all those agreements survive the termination of employment so long as they're written right, whereas a confidentiality provision in an employee handbook is pretty useless to you. If you're looking at non-competes provided to you by an employee who is under consideration to work for you, don't take the employee's word that the agreement is unenforceable. I had an employer recently that got bitten by this. They wanted to hire a guy. He said, I've got a non-compete, but I've reviewed it and it's not enforceable. And they just took his word for it. Well, it turned out, they sent it to me after they got a cease and desist letter from their the former employer, and it turned out it was actually enforceable. And so this employee just sort of said that, and they took his word for it. But it's fine to have your legal counsel review these agreements before you hire the person. And then you're going to look at what state's law governs, look at that state statute if there is one, or common law, make sure that the restrictions are reasonable, that other requirements are met. And then we won't get into the legal issues of red pencil, blue pencil, but that's going to be something your legal counsel will be interested in. Okay, I think that is non-competes in a very quick minute. So I'm happy to take any questions you have.
Fantastic. Thanks so much. And thanks for putting that together. I love, this is so interesting to me. So thank you. All right, a couple questions in here. So let's start here. I think you've answered mine already, so I'm going to move on down. So from a member, very secretive. We're highly specialized consultants serving clients all over the country. The location of a colleague's office, which in many cases is their home, and we have colleagues in 5 states, truly has nothing to do with their clients are located. Do we have any mention, do we have to mention geography at all of our non-compete, or would the omission just dilute its efficacy?
Well, you can, instead of mentioning geography, you can mention clients, and you don't have to mention them by name, but you can say, so this person won't work with any clients that they have served in a material capacity or something like that. So if they're serving clients in Nevada and New Mexico or something like that, but that's sort of their parcel of clients, you can restrict them to only those clients. And courts actually kind of like that, because then you're not just restricting them willy-nilly. You're saying just don't compete with me for those clients, and then otherwise you're free to compete.
Great, thank you. My employees are leaving my company, disregarding their non-compete / non-solicitations and going to work for themselves, not another company. Any advice? It seems like going after another company seems easier than pursuing action against an individual.
Well, so your agreement hopefully is written to include both restrictions on non-compete restrictions on working for another company or working for themselves. I mean, if they're competing with you, then they're a competitor. So, you know, you may need to just start going after people. You may need to start, you know, trying to enforce some of your agreements. It's a big slug of money, particularly if you're not sure you will get much out of it. Even with an attorney's fee provision, if your former employee doesn't have any money, it's going to be hard to collect on a judgment for those attorney's fees. But sometimes just letting them know you're going to enforce has a deterrent effect. I mean, you know, sometimes sending them a threatening letter or taking one or two of them to court will start to have the other ones say, oh, geez, before I just start flagrantly violating this, I need to probably, you know, be careful here.
A question I had, how can you protect yourself from being sued as the hiring employer? Like in this market, you're trying to hire everybody, you know, you can, but how can you do that on the front end?
Yeah, so always ask your candidates if they have not any covenant, you know, any restrictive covenants that might survive their past employment. So just ask them, and they don't necessarily know the terminology. So just ask them, hey, did you have an employment agreement with your prior employer? Can I see a copy of it? Or did you have a non-disclosure agreement? Did you have a non-compete agreement? You know, whatever you can do to ask them what they had, and they need to provide that to you, and then have your legal counsel review it. And sometimes I look at these agreements, I'm like, this is so non-specific, it's so ambiguous, it's so poorly written, or it's not in accord with the state statute in that state, it's not going to be enforceable. But sometimes I look at them, I'm like, yeah, this is enforceable. So if you are indeed a competitor, you're not going to want to hire this employee. On occasion, I have had employers who have reached out to the prior employer and said, we want to hire Rufus for this particular job. Rufus won't have access to any of our customers. You know, Rufus won't be able to use any of your confidential information. It's a limited job. It really isn't the same as what he did for you. Would you be willing to, you know, basically release Rufus to do this particular job for this particular amount of time? And sometimes they will. You know, often former employers, they don't want to screw the former employee. You know, they hope the former employee, especially if they're fired, they hope that former employee will go out and do good in the world and all that. And so sometimes they'd be willing to allow a limited waiver of enforcement of the non-compete. But in general, you really need to review those things. And then if it turns out the non-compete is viable, if the employee is violating it, you're probably going to want to jettison that employee, as frustrating as that is, because you've been through the whole, you know, recruiting, onboarding, and all of that. But it certainly beats a lawsuit for inducing breach of contract, which is what you would be faced with.
That's a tough one.
Yeah.
As the employer. So having the former employee pay for attorney's fees, what experience shares do you have either way, or when that was actually enforced, or even not able to be enforced, right?
Yeah, so that's typically enforceable. I mean, it's just a contract clause that says if the former employee violates the non-compete, the former employee is going to be liable for the employer's attorney's fees, court costs, et cetera, in seeking to enforce the agreement. And typically it'll say, you know, if the employer prevails in the lawsuit. So, but courts are willing to enforce those attorney's fee provisions if the employee has violated the agreement. You know, the issue is, how do you collect that money even when you have a judgment? And of course, you know, there's all sorts of ways to collect money. You can put a lien on people's houses and stuff like that. But I mean, you know, getting that judgment is not really, you know, a stretch, and courts are willing to enforce these things.
Can you do that on the front end? Like when you hire the person, if their former employer were to sue you as a business owner? Does that make sense?
Oh, you're talking about if you sue.
Just the other way around. I mean, you answered the question, but I'm just flipping it around.
So I've not seen where an employer has said, okay, employee, I'll I'll take on this lawsuit against your former employer, but you have to pay my attorney's fees. I haven't seen that kind of situation. I have seen where the new employer says, I don't think this is enforceable. I think this is an unenforceable agreement. And so I'm going to pay for my own company's attorney's fees. And I'm also going to pay for the employee's attorney's fees because we really need this guy. He's great. And this former employer is just trying to intimidate him and us to break up this relationship. And we think it's absolutely valid.
Got it. Thank you. Excuse me. You mentioned Jay Morgan, you mentioned California not being friendly. We're a Tennessee-based business that serves clients in California. Our California-based employees are the face of the company there. Is there any way to get a non-compete, non-solicitation enforced there?
So the only way I can think of to do it there would be, so California law says that California will not enforce another state's choice of law provision except where the California resident is represented by counsel at the time the agreement is signed. So basically, if your employee who is signing that agreement has an attorney advising them and they agree to a Tennessee choice of law provision, you could probably enforce that non-compete against that California resident by relying on Tennessee law. But how many of your employees who sign a non-compete are going to be represented by counsel at the time they sign it? And if they are, any lawyer worth their salt in California is going to say, I'm not going to let this employee sign this agreement with a Tennessee choice of law provision. It has to have a California choice of law provision, and then the non-compete is useless. So there's not a whole lot of good ways to protect your the relationship as the face of the company, other than all those other things, the non-solicit, there's another one called a no service agreement. So not only can I not reach out to a company to affirmatively ask for their business, but I actually can't service that company if they were to call me. And these are not always enforceable everywhere, but I will say California seems to be leaning slightly to the right. And I think it's because they know they've set up employers a little bit to be at a disadvantage. They've disincentivized employers from making investments in employee relationships and things like that. And they've provided employers in California a disincentive to share confidential information and to do business there. So I think they're starting to lean a little bit, and maybe a non-service provision in an agreement would help you sort of protect that relationship.
Awesome. Got a few more and then we're going to go to breakout. So question, should employees sign a client/vendor/referral list yearly to recognize the names on the list?
So that's a tough one, because I don't know that you would necessarily want to have a list published each year of your current clients that someone could then leave and take with them and use against you. I would say your employees probably know who the clients are that they service. They may not know who the clients are who are serviced elsewhere in the company. And you may not want to tell them that. So I see agreements often where the agreement says that the employee can't solicit any client or customer or prospective client or customer of the company. And, there's like 30,000 clients or customers of the company. How on earth would the employee even know who those customers are? And courts are kind of like, look, they didn't have any way to know this was a customer of the company. So I guess I'm kind of the thought that why tell them? So, instead just focus on the ones that they actually do interact with. And if they go after some customer that, they weren't servicing, they didn't even know about, in some respects, that may just be a relationship you don't really necessarily need to go after them for.
Perfect. I think two more. Can you touch on interference with the quote interference with business relations? So if you have an employee or an independent contractor that you decide not to enforce the non-compete, but this person is talking negative about your company, is there something else to do other than enforcing the non-compete?
Yeah. So Tennessee has both a tort and a statute that's basically the same thing: interference with business relationships. and it requires someone to knowingly interfere with your business relationship by basically going after that relationship, trying to break it up. So maybe trying to steal your client or customer, and doing so with malice, which is a little bit of a hard thing to prove. So they have to have some sort of bad intent, not just to get the business for themselves, but to actually hurt your business in the process. So it's a little bit hard to prove, but if you have a contractor that, you know, clearly went into this whole thing just to steal your business, you know, maybe you can go after them. There are attorney's fees provisions as part of that statute. So there's that, you know, you may be able to get attorney's fees if you do sue that contractor, or even if you didn't have that as a part of your contract. But, you know, typically it's those statutes are, that law is a little bit hard to prove that all the various elements of it so that you can actually recover. I mean, but people do, you know, companies do recover on these things. You just got to have pretty good proof of what happened.
Perfect. One more, and this will be a quick one. Statutory definition of trade secret. You're talking about trade secrets, and you specifically mentioned the statutory definition. So what's the nickel version there?
I don't know offhand. In Tennessee, it's governed by state law. State laws, just like with non-compete laws, state laws vary as to the definition. Some states protect customer lists, customer contact information. Some states don't. So you'll just want to look at your particular state law and see what is protected in the particular state where you're doing business. And that's why having your non-compete, your non-disclosure agreement mention trade secrets and company confidential information is important. So have both of those protected. Trade secrets are already protected by state law, but you may have confidential information that may or may not be covered under the trade secret law that you also want to protect. And you may want to list that particular confidential information. So it may be like marketing plans, financial data, customer, you know, how much money you make on each customer. I mean, certain information that really wouldn't constitute a trade secret that you want to protect in addition. And so you call that confidential information and you actually take steps to protect it by, again, limiting the disclosure of that information within the company to only those with the need to know, marking it confidential, and taking other steps to protect it.
Perfect. Perfect. All right, we've got about 10 minutes or so. I just want to do the quick breakout and then we'll loop back together. But there are 2 questions. Are they in the chat? Maybe. If they're not, I lost my notes. Go to your breakout and we'll join back up in about 10 minutes and see you guys in a second.